monster. She's a monster. His ex-wife is bonkers about money.
Well, it's not fair.
It's not fair. To her, send me money, send me money, send me money. This is what happens. It's not fair. How can I send you money when I don't have a job? See, that is just not fair.
To be able to use a phone.
How long will that take? Because I need to talk to Brian.
Welcome back. Today we have another little director's cut of this family trial, another portion taken from my overall 9+ hour family trial video, with today focusing on Brian and Sarah's opening statements and Brian's closing arguments. It is still unknown whether or not Sarah ever submitted her closing arguments. Nothing has been updated on the website, so we have to assume that she didn't, and that Brian's is the only one that we have available, and that she just threw in the towel. I mean, after that performance, I would have thrown in the towel too. Now, in my original 9+ hour video, I legit got a migraine by the end of it because it was just too much and just getting through it was taxing. But because of that, I never actually reacted to the closing arguments. I read it out because I had already pre-recorded it, but I never actually did my reaction to it. So that's going to be the one different part about this video, is that it includes my reaction to the closing arguments at the end. All the normal warnings out of the way. Hello, if this is your first time here, welcome to the world of long-form rant content, where there is no structure or goal, and it is just me reacting to whatever I want to react to, and the video is finished whenever it is finished. I claim no authority on this channel. These are just my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. As of right now, we still do not have a final judge's order regarding this case, so this is just another thing to do while we wait, and this is my excuse to host another live. And with that said, let's dive back in.
Do you swear to tell the whole truth and nothing but the truth?
I do.
It was all a lie. Guys, it was all a lie. She lied.
Okay. All right, we're here for a final hearing with regard to a supplemental petition for modification of alimony and child support, as well as a petition for relocation. I do understand that there was a motion granting the temporary relocation, but it's my understanding the court needs to still consider a final relocation on that issue. Before we get into that, there were a couple of motions that were filed by Ms. Boone that I'd like to address before we start. The first of which is a respondent's motion for contempt and to compel petitioner to submit visitation application immediately, that was filed with the court on August 20th of 2025.
Yeah, I surely did forget that she titled it like that, of motion for contempt and to compel petitioner to file these visiting applications immediately, which it's so unprofessional and weird, and this is why you don't write that way, because the judge has to read it as it was submitted, and she did a great job downplaying it, but I'm like, yeah, that sounds very foolish in open court.
If I recall correctly, one of the last times we were here, the petitioner indicated that he had filed something with the Department of Corrections regarding the visitation. They were slow to react, and he was going to follow up. Did the court remember that correctly?
More or less. I had sent them something.
Hold up, Ms. Boone.
I never heard anything back from them about it. So I guess they never got that one. I have since submitted it.
All right, when did you submit something?
The end of last week.
You have a date you can give?
I think it was Friday.
Friday, which would have been the 22nd, I believe.
Correct.
All right, Ms. Boone, Mr. Boone has indicated that he attempted to follow up after one of our last hearings regarding the status of the application for visitation. He never heard anything, so he submitted another one on Friday, August 22nd.
Your Honor, am I allowed to expound on that?
Yes, you are.
Well, I know for a fact that I'm actually in the classifications department now, and as of this date, no visitation applications have been received on his end for himself or for my son.
It was all a lie. Guys, it was all a lie. She lied.
What do you mean you know for a fact? That doesn't make any sense. You know for a fact because you work in the classifications department that he didn't submit his visitation application. There's just so much wrong with this. One, this was on the 22nd, which is a Friday. This trial is on the Monday, the 25th. So in those 3 days, of course, you would not know anything about this. Also, second, you would not know anything about this. Your inmate job does not actually give you access to private personal information, at least not first. You're in a clerical support job. You file things, you look over this and all the stuff people don't want to do. You are not sitting there in like the control room being like, well, did we get the new file update? Let me just check the system. Let me log in and just look around and see if a visitation application has been submitted. You would have no idea either way. But you say these things with such confidence as though the judge would not know this. I mean, I guess it doesn't matter. No one's going to push it that hard, but that is just so funny. I actually work in the classifications department, and he hasn't submitted a visitation application, which I looked into it for. Lowell is sent to a completely different email, is checked by institutional administrators, and doesn't go through the classifications department at all. The classifications department deals with the classifications of the prisoners, housing, custody levels, programs, stuff like that. It has nothing to do with anyone in the outside world. Okay, but I will be fair. Yes, this was a cover your ass move by Brian to submit the application on the Friday before trial on Monday. But the court never gave a deadline saying you need to do this in advance by such time. It just said you need to do this before we come back here, and you did it. You had an answer, she wrote it down, so you're good. So we are starting off strong, and we are already in for it. We know she's going to manipulate anything she can, and none of us should be surprised.
And no attempts also have been made in order for him to try to do so in the meantime. I know that our pre-trial conference was on May 29th, and you gave them a 2-week deadline to submit. And I believe also that
is the 2-week deadline in the room with us right now.
It was all a lie. Guys, it was all a lie. She lied.
Because I don't remember that. I remember she kept bringing it up, saying that happened, but she always says this. She says in the trial, in the court hearing, you gave this blank verbal order and you told him blank and he didn't do it, but somehow those specific words never end up in the actual order.
his attorney even volunteered to submit them himself due to the prolongation of time for the now ongoing 9 months that I've been trying to get him to submit for no reason of him withholding submitting the visitation application. So that's why I put in my cross notice and again my motion for contempt at this point, because they have disregarded your verbal order or instructions to submit them within the 2 weeks as of May 29th.
What do you mean verbal order? Why do you keep saying that? There's no such thing as a verbal order. I never understood that. And she says it so confidently every single time.
All right, I'll have counsel respond.
Yes, thank you, Your Honor. So in order for someone to be held in contempt, the court has to find that they willfully and intentionally violated an express and clear provision in a order or an agreement that was ratified by an order. I'm looking at paragraph 5 of the order that references this Department of Corrections application. And it says, Respondent also raised concern about Petitioner not preparing an application required by the Department of Corrections so that the minor child could visit her. There was no pending motion before the court on this issue, but Petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application.
What? You mean that doesn't specifically state you have a 2-week verbal order deadline that you will be held in contempt if you do not submit these visitation applications immediately? No way. Like, literally, I don't think a single word of what she said was in there.
There's nowhere in this paragraph where it gives gives Mr. Boone some sort of clear and express deadline to submit anything, or that he would be held in contempt, or put on notice that if he didn't do something by a specific date, that he could be held in contempt by this court. With that being said, Your Honor, I do understand that it's the court's wishes, and it's my client's wishes too, to get this set up as quickly as possible. Mr. Boone has resubmitted a second time now the application on the 22nd of August, according to his sworn testimony. I'm assuming that whatever Ms. Boone is seeing right now, maybe it's not updated in the system.
She's not seeing anything. She's just saying that. She would have absolutely no access to that. The most she can do is beg, nag, and plead officers or guards to look into it for her. And if the last time that she begged them, they said that they didn't see it, if they even looked at all, then she wouldn't know. Just because it would be a visiting application for you does not mean you inherently get immediate access and updates to those applications. But whatever. And he knows this too. He's just not going to call that out.
I don't know what else Mr. Boone can do to address this concern, but certainly being held in contempt would not be an appropriate remedy based on the language of the order in question.
All right, I will allow you to briefly respond, Ms. Boone.
Thank you. After the pre-trial conference, he also was under oath as well and told the court that he made an attempt, and he has not made an attempt. Nonetheless, that was 3 months ago. And you did give them verbally a 2-week deadline. And again, verbally, his counsel volunteered to
All right, Ms.
submit the
Boone, I
application.
cannot enforce any verbal statements that were not in an order.
Yeah.
Exactly. And there it is. About time. I mean, like, and she just had it, like, she just kept going because people were letting it slide, and she's like, and you did verbally, and you did verbally, because it's the only thing that she thinks can't be fact-checked. And that's why verbal orders don't exist. But she did the same thing in her interview, or the car interview with Chelsea, when she keeps saying, I'm afraid for my life. I'm so afraid for my life. Well, they haven't actually threatened you or done anything to you, so we can't do anything. They threaten me all the time.
So we're going to cross that bridge when we get to it. I know you're fearful of it now, but nothing has happened to where you're in fear based off past history and what they think of you and how they threaten me all the time. Do you have proof, or is it all verbal? Like, would it be in your phone?
No, it's verbal.
Okay.
It's verbal.
So it's he said versus she said, or she said.
Yeah, they've been really nasty to me. Really nasty to me.
Well, do you have proof of it in your phone? Oh, no, it's verbal. It's verbal. It's all verbal. Because it has to be verbal. And then she wants you to act like verbal is a full-blown admission and confession. And she says, your last time he was under oath and he didn't submit it. How do you know? He just said that he never heard back from them. So he resubmitted it again this past Friday. And if that's a lie or not, that's his business. However, he has an answer to that. You have no proof he didn't. In the 2 weeks you just pulled out of thin air. Maybe she brought up the number of 2 weeks in the hearing. And she does that a lot too, of if she brings up her own version of events and she gets anything that's even somewhat on her side, then that means they adopted her entire answer. She said 2 weeks, and then the judge told you that you need to submit it. So obviously, Linda, exactly. It's because whatever number she comes up with in her head is the number that the judge said. Oh, bars? And this is just a pattern that we've seen repeated time and time again with her. You can just imagine how she was on the outside. However, now you're actually saying it in front of a judge. You like using the judge and you like threatening people with the judge. Do I need to tell pretend judge this?
It doesn't matter how dumbed down I am to myself to try to coexist with her. I've even come up with a solution to have a pretend judge in the interactions with her, so she would try, hopefully, to treat me appropriately and professionally, which she does not do.
I added pretend judge to our interactions so she could calm down and ease up on her condescension.
Do I need to go to the judge? You realize this is why we need to go to the judge, Brian, right? Because you won't cooperate.
Is it because I'm trying to send all of my documents to the judge about you that you are not allowing me? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you in Gainesville, than in court where you can answer everything when the judge asks you or orders you to answer? Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right?
And now that we're in front of the judge, you keep trying to pull the same manipulation tactics, and she's gonna smack that shit down every time.
I specifically put in the order because there was no motion at the time. We did address it, and I did want there to be note that we addressed it, but there is no specific order requiring Mr. Boone to do anything by any specified period of time. And by law, because there is no order, I cannot hold him in contempt.
Bon appetit!
For failing to comply with an order.
Is there a way that, it's been 9 months that I've been asking from him to submit these visitation applications. There's no legitimate reason for him doing so.
Why is this happening?
Because George is dead.
And I don't have any record of who he spoke to supposedly when he did try to contact DOC, and then also a confirmation that he's done it this time, 9 months later and under oath. How can I go about doing so to make sure that this is actually being done?
All right. With that, I am going to deny without prejudice the motion for contempt.
Yeah, double homicide.
Damn. She completely sidestepped that and said, excuse me, skirt, that is not what we are here to do. I'm going to deny the motion. You submitted a motion for contempt. That is what we were discussing. There was no time limit in the order itself. You were allowed an opportunity to respond. There's nothing you could have responded to. So literally anything you said would not have changed the outcome. However, she did say, I'm going to deny it without prejudice. Without prejudice means you can refile it in the future if you do it properly. Linda is locked in today because you are absolutely right. She has had this misconception of judges in general since the beginning. She thinks the judge is there to solve her problems. No, they are there to mediate and apply the law constitutionally and fairly. They take what is in front of them. They cannot add context or facts that you did not put in there or allow room for them to add. That's why you have little things like, and also provide any relief that you deem just and proper, giving the judge that authority to do whatever they want. Otherwise, they can only go by what is presented in front of them. Okay, we have to move on.
I do not find that there is any willful violation of a specific court order with regard to a visitation application. All right, there was another motion that was filed by you, Ms. Boone, respondent's motion to appear in person for trial. That was also filed on August 20th. I will hear you on that motion.
Obviously, since she's on the telephone, it didn't work out for her, but I never read this on this channel, so let me just read that motion real quick and we'll pick this up. Respondent's motion to appear in person for trial. Comes now, pro se respondent, Sarah K. Boone, and respectfully moves this honorable court to issue an order for her transport to rightfully and properly represent herself by being included in person for the final hearing in her family law trial on August 25th, 2025. In support of the respondent's request for equal, full inclusion, 1. Respondent has been ordered by the court without hearing, July 28, 2025, to appear and participate telephonically in this trial due to her incarceration. 2. By, quote, appearing via telephone for this trial, life-changing trial, the respondent's rights and position are heavily impaired, increasing an unfavorable outcome in her self-representation by being excluded in the courtroom with all other parties, in which she is and should be included as such. 3. In-person representation is crucial for the respondent to ensure meaningful access to the court by having the ability to present evidence for her defense, cross-examine witnesses, respond appropriately to arguments made by the petitioner, and accurately perceive the dynamic of the courtroom as a whole. 4. As a self-represented, pro se, litigant, the respondent is at a significant disadvantage when, quote, appearing by phone, especially in a complex trial setting where immediate review and understanding of documents, real-time responses to developments as they arise, communication with the court, presentation of exhibits, observing the opposing party's demeanor is necessary. It is essential for her to engage in all court proceedings for this trial. 5. Remote participation impedes the respondent's ability to fully advocate for her position and interests, particularly given her documented difficulties in accessing legal materials, submitting and receiving documents from the court and opposing counsel, and communicating effectively from within the correctional facility. 6. The respondent's physical presence and participation greatly minimizes the risk of technical difficulties, which can delay, interrupt, or obscure communication, and allows the respondent to interact directly, clearly, timely, preserving the court's invaluable time. 7. The respondent's transport to the court and proper inclusion in the courtroom serves the legal interest of due process, increasing her ability to be rightfully understood as a serious and committed party in this case in respect for the court, ensuring fairness and justice under her extraordinary circumstances. The Florida and United States Constitutions. Wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order for transport to fully have the ability to represent herself in this family law trial, and after her continued determination, eagerness, hard-fought effort to do so for a hopeful legal and just outcome for over five years. Respectfully submitted this 8th day of August 2025, Sarah K. Boone. Oh my gosh, everything is so loud around me. That is aggravating. Hope whoever's in trouble is okay, but not as aggravating as this motion. No, I get it. You want to appear in person. I didn't think they'd have you by telephone, but also this isn't a criminal trial, so they are not held to the same standard to make sure you have all the access in the world. Communicating by telephone, I'm sure, is rough, but it doesn't impede your access to the court. As we see right now, we can hear you clearly. You can hear them clearly. You being able to observe the body, the demeanor in the courtroom doesn't mean anything. I guess it would help you understand when you're going to flounder and to stop and be quiet. But that's never been your style. Even when you were in the courtrooms, you acted the exact same way. But she's just going to use this as an excuse to say, this was so unfair. The only reason I'm so disadvantaged is because I wasn't in the courtroom to manipulate you myself. You only got to hear my lies. You didn't get to see my pouty little sad face.
Well, I'm on the telephone, so it does me no good at this point, Your Honor.
All right, are you withdrawing that motion?
I am.
Thank goodness. I mean, we knew she did because there's like 3 hours left of this trial, but she could have made a huge stink about it and said, no, I need to be in that courtroom. I haven't been heard. There was no hearing. You made me go on the telephone. I wasn't prepared.
Sometimes I'll start a sentence and I don't even know where it's going. I just hope I find it along the way.
The judge probably still would have denied it anyway, but there is a future where she could have paused everything or postponed it in order to have you transported. Who knows?
All right, hearing that you're withdrawing that motion, I'm going to deny that motion as being moot.
Bon appetit.
Now we can move on to, with regard to the petitions that we're here on today. I'm going to start with the petition for relocation. Ms. Boone, do you oppose the petition for Mr. Boone to relocate with the minor child to?
I do not oppose.
Well, I'm sure you don't, but this is the first time you ever said it. You've been in opposition for years over this move, saying, how dare you? You're just assuming.
We don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud, the phone is distorting. So loud, former husband, his father, came in and told him to stop being mean to me before hanging up. Honorable Dean, this is what was told to me by my 11-year-old son when I asked about his best friend and how she was doing since I hadn't mentioned her in a while. He told me she started acting strange after he told her he was moving and wouldn't see her anymore. She's upset with him. The conversation continued with me asking why he's telling his friend this, as nothing is set in stone and will be discussed when the time comes.
Because she got so mad, he said, well, we're going to be closer to the prison.
Told me, when you're finally put away, this move will be the best thing to happen to us. Him, son. We can't wait to get out of Orlando and away from you. Laughing. Also, where we're moving is very close to the prison. It's going to be very easy and convenient for us.
And she could not believe anyone would even conceive that she would be sent to prison for the rest of her life.
Court sentences you to life in the Department of Corrections.
Yet here we are, and now she has no issue with them moving. We knew she wouldn't, but I'm pretty sure this is the first time she's officially acknowledged that.
All right, hearing that there is no opposition, I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to, and hearing no opposition to the motion, the petition for relocation, I'm going to grant that petition.
Your Honor, am I allowed to say anything in regards to the contents of?
If you're not contesting it, I don't need to hear anything about it.
And Sarah is not going to understand anything about this whole trial of, this is not a conversation. Once things have been ruled on, we are moving on. You don't get to just pick apart some of it. If you agree to the relocation, you agree to the relocation, and we keep going. You don't get to say, well, I didn't like in there how they framed this and framed that. Okay, next.
I am contesting some of the points that they have in regards to some of their other motions and modifications. Just things that I would like to apply to it from this motion.
Okay, that doesn't make sense. You can't, either you agree with it or you don't. You can't say, I agree with the relocation, but also I still want to argue it. No, we have things to do, people to see, rulings to make, money and custody to take away from you. Things have to get moving. But one thing I noticed that I haven't actually brought up yet is she flat out said, I am adopting the prior court's ruling of finding a substantial change in circumstance which necessitated the move of Brian and son to wherever they live now.
I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to.
So from moment one, she is stating, I agree with the prior judge, and Sarah didn't put this together, that the prior judge agreed with Brian in saying we have reached a substantial change in circumstances, which is the number one most important factor in determining whether you can modify an alimony agreement or not. If there is no substantial change in circumstances, then no, you don't get to modify anything. She is banking on the fact that in this hearing, they can't prove that there's a humongous, substantial change, and that's why she needs to get paid all the money that she is quote-unquote owed, entitled to, lawful alimony, etc. And all that to say, before we even got started, she already lost.
All right, the petition for modification is solely for Mr. Boone to move to with the minor child. Are you opposing him moving to with the minor child?
Your Honor, you said the petition for modification, the petition for relocation.
Excuse me, the petition for relocation. We're not dealing with the petition for modification just yet.
Okay, no, I do not oppose the modification for relocation.
All right, so as I stated before, I'm going to grant the petition for relocation. Petitioner's verified petition to relocate that was filed on February 14th of 2023. All right, that puts us to the petition for supplemental petition for modification.
Your Honor, if I may just have one question about the relocation petition.
Okay.
Does Ms. Boone also agree to adopt the proposed amended parenting plan that we submitted in regards to the relocation? Because that is still.
Okay.
I just need to know if I need to present evidence as to that point.
All right, so we will hear evidence with regard to the parenting plan as it relates to both the verified petition to relocate and the supplemental petition for modification. All right, do we wish to have brief opening statements?
I would like the opportunity, Your Honor.
All right, so Ms. Boone, I'm going to hear brief opening statements first from the petitioner, and then I'll hear your brief opening statements. And again, we're only dealing with the issues on the supplemental petition for modification of alimony and child support. And I believe also you all wanted sole parental responsibility, is that correct?
Yes, Your Honor.
And then also the proposed parenting plan with regard to the relocation. Okay, once counsel for petitioner has done with their opening statement, I will give you an opportunity to also present an opening statement, and then we'll go right into evidence, okay?
Yes, Your Honor.
All right, I will hear petitioner's opening statement.
Do you mind if I go to the podium here?
You may.
All right, well, good afternoon, Your Honor. We're here today, as you've already outlined, on a petition to relocate and a petition to modify. I can cut out a lot of my opening statement because it sounds like Ms. Boone has agreed to the petition to relocate. What the evidence is going to support and what we are going to present evidence on regarding the parenting plan for the petition to relocate is that we are proposing that Ms. Boone have a 1 monthly visit with their 14-year-old son at the correctional facility that she's located in Marion County, and that she be also entitled to a minimum of 1 weekly phone call with the child. And we are also asking for sole parental responsibility regarding the day-to-day, or not only the day-to-day decision-making regarding the child, but also all of the decisions related to the child. We believe the evidence in this case, considering what has transpired since February of 2020, would support a order of sole parental responsibility when it comes to parental responsibility. I think the most contentious part of this case, Your Honor, is going to be the discussion regarding whether or not Ms. Boone is owed money.
Send me money, send me money, send me money.
Our position is that, Your Honor, actually Mr. Boone is owed money, but he's willing to waive that and just to have both parties owe each other nothing moving forward. What evidence is going to show, Your Honor, is that since February of 2020, Ms. Boone has been incarcerated. She was charged and arrested for second-degree murder.
Why is this happening?
Because George is dead.
And has since been convicted.
We, the jury, find the defendant guilty of murder in the second degree.
By a jury of her peers of second-degree murder in December of 2024.
Juror seat number 1, is this your true and correct verdict?
Yes, it is.
Juror seat number 2, is this your true and correct verdict?
Yes, it is.
Juror seat number 3, is this your true and correct verdict?
And she is serving now a life sentence.
Ms. Boone, court sentences you to life in the Department of Corrections.
Since February of 2020, Mr. Boone has been 100% financially responsible for their now 14-year-old son. At the time that Ms. Boone was incarcerated, what evidence is going to show is that Mr. Boone stopped paying.
Hide the money, y'all. There's poor people around. With your broke ass.
The $1,000 per month of alimony and the $100 per month in child support.
With your broke ass.
That was ordered pursuant to the June 15th, 2018 final judgment of divorce between the parties. Mr. Boone will testify and evidence will support that for multiple years after the respondent was incarcerated in February 2020, Mr. Boone continued to give Ms. Boone financial assistance in the form of commissary payments, other payments, and also maintained a mini storage for her for multiple years after she was incarcerated, despite having absolutely no legal obligation to do so.
Oh, so now it's official that he was the one who was taking care of the storage unit. We know that he had access and was putting stuff in there. I didn't know if she had a storage unit from beforehand, after she moved out from their house originally, and then she just gave him all the stuff and asked him to take care of it. But it sounds like he got the storage unit to begin with, and then was paying for it and had all her stuff in it, and then said, I'm not doing this. He has had and will always have absolutely zero legal obligation to help you with your personal property after you get in prison for life for murdering someone. These are all you issues. He was nice enough to take it on in any respect or capacity, but he was never obligated to, and you treated him like he was. If you treated him like he was doing all the favors that he was doing for you, then you wouldn't be in this situation. Because for some reason, people seem to have so much nerve, I don't want to say empathy, but it feels like nerve is correct, to deal with you and allow you to get away with all this stuff, that he probably would have been fine if you just weren't berating him daily about where's my personal property, where's my storage unit, let me put it in these motions to try to get you in trouble, as if you weren't doing me a favor. And she tried to make it sound like, well, it was a verbal contract. You agreed to take it voluntarily and without any cost. You need this in writing. And if you don't have it in writing, then this is not a verbal contract. Why? Because for verbal contracts normally to be binding, both sides have to get something from it. He's taking care of all your stuff. In my mind, I thought all of this would originally offset the alimony payments, but nope. She's here saying he never paid me anything ever. He did all of it out of the goodness of his heart, and now he's legally obligated and responsible for my property. If he did it out of the goodness of his heart, it was a favor, and that's on you. If you had said that our trade-off was he was going to keep track of my personal property in exchange for subtracting that from alimony payments, and then he stopped doing that, that's when you can start to demand the $1,000 again. But you were demanding that on top of absolutely everything that he did for you. She will never truly know all the things she had until it's finally taken away, which is about to happen.
to maintain that mini storage. What evidence is going to show is that when she was incarcerated, actually, Mr. Boone helped her remove her stuff from the apartment that she was living in at the time, and was really one of the only people that assisted her during that time and acted in good faith to help the mother of his child during that time period. What Mr. Boone is going to testify to is that throughout that time period, he averaged about $600 a month in direct payments to Miss Boone and also in-kind payments towards expenses that should have been Miss Boone's obligation. Also, what evidence is going to show is that since February of 2020, Miss Boone had approximately a $370 child support obligation to Mr. Boone. And the reason why we believe evidence will support this is that under Florida Statute 6130, subparagraph 11, subparagraph C, despite the fact that the petition to modify was filed in April 12, 2022, that the court is within its authority to modify child support retroactive to the date a parent first failed to exercise their time sharing pursuant to the final judgment.
Exactly. Something she has never acknowledged, nor does she care. She doesn't care that she was only receiving child support, $100 a month, because she had equal time sharing with the father. And that without having the child, that means she had the obligation to support him. The fact that he still had to keep paying her, or at least put the money in another account as if she did have the child, is wild. But in real life, if you miss your time sharing obligation like that, you now owe your own child support obligation, which she's going to completely ignore and say, well, I was incarcerated. I didn't choose to be here, so I shouldn't have to pay. I have no money. What am I supposed to do? Well, how about you give up the money that you keep begging for? But Sarah will want you to ignore that, and she will ignore it. I can guarantee she's not going to bring up her own child support obligation in this entire trial, and will get mad when you do.
Ms. Boone, pursuant to the final judgment, had an equal time-sharing schedule, and then, of course, in February of 2020, that time-sharing went down to 0, and she had 0 overnights. She's had 0 overnights ever since. So therefore, the court can go back to February of 2020 and consider what the child support obligation should have been, considering that she did not exercise her time-sharing, and give Mr. Boone a credit for what the child support should be. And we'll be presenting evidence as to what we believe that number should be, imputing minimum wage to Ms. Boone and also imputing $60,000 a year of income to Mr. Boone, despite the fact that he's currently unemployed. Also, Mr. Boone, since Ms. Boone was incarcerated in February of 2020, has accumulated over $14,000 in attorney's fees.
Yeah, double homicide.
Bitch.
No, I'm sorry.
Trying to modify the final judgment and trying to be able to successfully relocate his son to Gainesville. This morning was the first time that Ms. Boone has made any concessions regarding any of the outstanding motions that were filed by Mr. Boone and the petitions that were filed by Mr. Boone, despite having really no articulable argument against the relocation. And the court should note that in the order on temporary relocation that was entered by a predecessor judge in this case, articulated that Ms. Boone, even at that hearing, seemingly had no articulable reason to object to the relocation, yet she still has forced this final hearing and forced Mr. Boone to incur attorney's fees for another 2+ years while we continued to litigate this matter.
Exactly, because at any time she could have withdrawn her objections to the relocation and they could have just gone about it. She could have just signed it away, but no. The judge ordered it to be temporarily allowed, and she even said in all those things or whatever, the order to relocate is temporary. I'm not going anywhere. You're taking my son 150 miles away. How am I going to get my life back together when I'm freed from murdering someone?
Please provide the permanent documents. Full custody and suspension of child support. Former husband's attorney was instructed to forward for your modifications, Your Honor, to temporary as requested. After I was able to explain my circumstances with having no money or family to hire an attorney once I am released.
Court sentences you to life in the Department of Corrections.
And my desperate need to be fully and completely reunited with my son ASAP.
Life in the Department of Corrections.
You graciously made the decision to make everything temporary. Thank you.
And now that she's not free, she's like, well, obviously I don't object to it. However, the temporary relocation is now done and we have to make that permanent. So it has to be brought up here again. So I can see how that could be annoying, at least enough to mention of there's no reason that she had for us to not move in the past. The only reason she did not want them to move is because that admitted that she was guilty, or that meant that she was going to be found guilty, and her personal big girl feelings got hurt. So she decided to make him hire a lawyer in order so he can legally bring his child to safety, which is as far away from you as possible.
So another thing that we believe evidence will support and what we're going to be requesting here today is that the court take into consideration in its equitable powers the amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Miss Boone's voluntary act, criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation, which has had a direct result in Mr. Boone having to incur tens of thousands of dollars of attorney's fees. And so if there is, even after the consideration of the payments that were made to Mr. Boone, from Mr. Boone to Miss Boone during the period after February 2020 moving forward, the retroactive child support that Miss Boone ordered, if there still is potentially a retroactive alimony amount this court is considering, we are asking that the court also, in its equitable powers, consider the $14,000 in attorney's fees that Mr. Boone had to occur, and that the court would apply that to any potential technical arrearage that Mr. Boone might have. And when we say technical arrearage, Your Honor, technically speaking, while child support is can be retroactive to the date that a parent stopped exercising their time sharing, alimony modifications are only technically speaking retroactive to the date that a petition to modify was filed. And so we're looking at that basically 26-month time period between February of 2020 and April of 2022 when modification was filed. It's also important to note, Your Honor, that evidence is going to show from the date that that petition was filed moving forward that it is appropriate to terminate Miss Boone's alimony obligations, obviously, or alimony award, because she has no need for day-to-day living expenses when she's incarcerated and having the state pay for her day-to-day needs. And so it is appropriate to terminate alimony from April of 2022 and also to give Mr. Boone a credit, and we'll be presenting evidence on that. Also, we're going to be presenting evidence, Your Honor, as to a sum of money that is currently being held with the Orange County Clerk of Court. It's over $4,000 in child support and alimony that's being held that has not been released to Miss Boone. And we're asking that the court order that money be released to Mr. Boone so that he can use it to help raise their child that now he is unfortunately having to raise completely by himself. A single mom who works 2 jobs, who loves her kids and never stops, both physically and financially. Lastly, Your Honor, there's been some motions filed, and this was mentioned in Ms. Boone's pretrial memorandum, so I'm assuming it's going to be brought up here today. Ms. Boone is alleging that Mr. Boone is unlawfully in possession of some personal property of hers.
Immediately upon the respondent's incarceration, Petitioner took possession of her vehicle directly from the sheriff's office and secured at the marital home. After verifying the placement and safety, he verbally promised the respondent to manage, and both parties mutually agreed upon him taking full responsibility of her property while her case was in progress. Petitioner also proposed and coordinated a storage unit where her belongings from her townhome were placed and secured. She repeatedly inquired about her personal property from the petitioner to ensure protection during, including setting up other arrangements at no cost in case the petitioner refused and discontinued to cooperate in paying his obligated alimony to cover. Petitioner would continuously tell respondent to, quote, not worry, quote, I've got it covered, quote, nothing is going to happen to them, quote, it will be taken care of. When she would ask for a status update to make sure he was really doing as promised to save her last ultimate resources and generational legacy to share with her son. Respondent felt the petitioner was being untruthful after not receiving any updates other than the aforementioned for years, and coordinated turnover of her vehicle's keys, locks, and keys for storage with information to be given to her brother, who lives locally, for safekeeping and to provide relief for petitioner, peace of mind for the respondent. After concerned repeated efforts and no-cost solutions by the respondent to acquire her personal property, keys, etc., petitioner finally stated, quote, the keys were lost in the mail. Since this last statement made by petitioner, respondent utilized her outside resources to locate information for this case and possibly filing an unlawful disposition suit against him, found out her vehicle was scrapped, junk salvaged, and storage unit auctioned off due to abandonment.
What?
Respondent made every effort to save her personal property, provide answers, multiple solutions, and arrangements to the petitioner for these to be successfully taken care of and protected during her incarceration, after petitioner promised and continuously assured her would be. Petitioner had legal duty to return or inform respondent before disposing of or abandoning her property, and should lawfully be liable for total cost and damages of.
There is no court order that Mr. Boone is in violation of regarding that.
What?
But here's what evidence will support, and here's what Mr. Boone is willing to do, is that he does have, when he finally stopped paying for the mini storage, Your Honor, he did move items out of the mini storage to his home that are Miss Boone's personal property. He still has those items there, and if Miss Boone has any relative that wants to pick those items up, he has them packed in boxes, and he will be testifying that he has no objection to releasing those items to a family member of Miss Boone. Thank you.
Solid, clear opening statement. Couldn't ask for more. The case really is this cut and dry. Just like the criminal case, she is an enigma herself that makes very simple situations seem like the most complex escape room imaginable. The issues are never that deep, despite her endless objections to the contrary. In her criminal court case, you killed him because you admitted that you zipped him in there, and you filmed yourself right afterwards, acknowledging that you did so. But she can't believe you won't make that situation more complex than it is. And we see the same thing in this case. He should not be paying you alimony after you have been imprisoned for life.
To life in the Department of Corrections.
After murdering someone. He should not pay you child support, as you will never have custody of that child again. He should have sole parental responsibility, since he has sole 100% parental custody of the child, and having to wait and balance and check in with an inmate who has only demonstrated a pattern of non-compliance and being more difficult unless you make her, in her opinion, the most important, correct, best things out there. Of course, he shouldn't have to go through that. Yet, here we are. It's been over 5 years, and she's been drawing this out as though she has been a parent on the outside, just as involved and entitled to how Mr. Martell puts it, the benefits of parenthood. But we're all aware how simple it is. Now let's see how complicated she tries to make it.
Before you begin, Ms. Boone, am I understanding that petitioner concedes there is 15 months of alimony that should have been paid? And so there is a amount that's owed, I believe it's $1,000 per month, so that would be $15,000?
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
Okay. All right, Ms. Boone, would you wish to make a opening statement?
I will do my best, Your Honor.
I'm sorry,
Thank you.
say it again.
I said I will do my best. Thank you for the opportunity.
And she's already trying to get the sympathy card. I'll do my best. Thank you for the opportunity. Sounding like she didn't know this was going to happen today. But I get it. She's mad she's not in there, and she's mad that they didn't appoint her a free lawyer and do this and do that, whatever.
All right, you may call your first witness. Oh, I'm sorry. You said yes? I'm sorry. It's hard to understand you.
Yes, I would like to make an opening statement, please.
Okay, you may proceed.
See what happens when you answer a question properly? People know what you actually mean. So when she asks you the first time, do you want to make an opening statement? And you're like, boop, ba-doop, ba-doo, well, I'll try my best, thank you. Is that a yes or a no? We don't know. She was about to move on to his witnesses. Then when you finally say yes, you get to go.
First off, I would like to say that I am having to represent myself. I am pro se. I am not an attorney. I am not educated. I have not gone to school.
What?
I am not an attorney. I am not educated. I have not gone to school.
I don't think you all understand who I am, where,
Okay. Well, tell me.
I mean, I've always been a straight-A student.
What?
I am an outstanding mother to my son.
What?
I excel at everything.
What?
Because I have never dealt with anything like this before. I don't know what to do, how to do it, and I always know what to do and how to do it.
What?
And I'm doing my best with the limited resources that I do have.
I'll do the best I can with what I got.
And also when the petitioner and his counsel decided to include me on documents and whatever exhibits and evidence it is that they are proposing that they have to present to you while in the courtroom, and I am here on the telephone.
Is the pause for dramatic effect supposed to do something? Yeah, we got that. That's so weird. Like, you're at the trial. You are there to convince the court. She's right there. She knows all this. She knows you're representing yourself pro se. She knows you're on the telephone. And yes, she will give you little brownie points for that. Not really, but like leniencies towards that. But when you try to shove it in people's face, it makes people want to do less and less for you. But it's what you do.
I also would like to say, please, Your Honor, that the evidence that they are trying to hold against me in regards to the $600 storage unit, the $370 child support, the attorney's fees, a lot of these things could have boiled down to simple communication. Would they have taken advantage of any of the mediation opportunities that were presented by the court? That a lot of these could have been resolved, including the temporary location that could have been discussed and proposed and agreed upon. Also, another opportunity could have been had in the mandatory attorneys meeting and unrepresented party meeting that we were supposed to have pre-trial conference before that. And again, the defiance is not in myself, as I have been 100% transparent, cooperative, and trying to do my best with whatever it is I can in order to prove my side and the truth, and to show my adamant intentions of being included in my son's life and trying to accrue what it is that I have been legally entitled to in regard to alimony and any arrears attached to that.
Well, that was a mouthful. That went nowhere, as per usual. Saying the evidence they're trying to show with the storage unit, the child support, the attorney's fees, this could have all been solved with a simple conversation. How? How is a conversation going to offset the attorney's fees, the money for child support, and the money for the storage unit? You have never once indicated that you are okay with them not paying that, or that you were going to pay that and compensate him for what he has done in the past and what you still asked him to do present and in the future. So no, a simple conversation would not have fixed that. You think that if you just had this, quote, mandatory attorneys meeting, which, you know, what I will say is it would have fixed the temporary relocation. They could have come together and agreed, okay, we don't need to bring up the relocation in the trial because we agree on that. That is what could have been resolved at the meeting. But the things that actually had to deal with money that's in the balance, a simple conversation was not going to change that. You were going to have to concede to things, and if you were not going to do so, we were going to end up right back here again. Because I think she believes that if she had the conversation, she could convince him to guilt him into keep paying for all these things for her. Because he's done so in the past, and she would have been like, I'm the mother of your son. And she says, the defiance is not on me. I have been 100% transparent and cooperative to prove my side, ... and the truth, because the truth and her side are not the same things. And regardless, she's not trying to prove either. She never really proves her side. She just wants to say, I have a side, and you should give me what I want because I said so. You have not been 100% transparent, because how many times have we brought up this example, which I imagine is going to come up multiple times in this hearing, and it's because of the fact she keeps circling saying that the petitioner didn't do anything with mediation. They didn't take any advantages of the mediations that were offered by the court. The court didn't offer any mediation. The court said that you all can have a mediation on your own. You can schedule it. We can put this on the docket, but it wasn't the court that was the one who was doing the mediating. The court said, cool, y'all are going to do this, figure it out, and come back to me when you've gotten that figured out. And they came back and said, hey, we tried to set up a date so that we could do this. She did not want to cooperate whatsoever, regardless of what she says. She refused to be the least bit cooperative with what they were asking. The fact that all they did was ask her for some dates of when they would be able to meet to go over this and to have the mediation. But Sarah always has to get the guilt trip, the woe is me type thing. So it's the I have cancer, there's no way I can do this, woe is me. We shouldn't even have to do this to begin with. You should just automatically give me money, and be okay with paying for everything until the end of time.
Mr. Martell, I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but have a few concerns and questions before doing so. First, I would like to make it known I have been diagnosed with cancer and am awaiting outside professional medical consult and treatment options. I do not know the level of severity, duration of time, or outcome for any of this, nor the effect it will have on my case, which I am currently incarcerated for, or the case at hand with former husband. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify, other than a letter from your firm telling me what I have to do? Is the point of this mediation to try to force me into signing or agreeing to the only terms available presented by former husband? Or are my modifications going to be allowed for discussion also in order for both parties to be included in the final agreements for and with the best possible outcome? 9. What if I do not agree? As said, I do not know what date is best for me considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response is greatly appreciated, as well as providing all requested documents and information.
Yet in her world, none of that was defiance. That was her being transparent and trying to cooperate in every way imaginable. And it's actually the petitioner who's not cooperating by giving her absolutely everything she asked for and yet again was not going to pay for. So there's always going to be a reframe of, regardless of what you do, what you give her, what opportunities you try to make available, she will always deflect and redirect. If you had the meeting and you still wanted her to pay or wanted to not pay her, she would have said, well, they didn't take advantage of the meeting. I went into the meeting trying to be as cooperative as possible, trying to come up with solutions for everything about anything, and they just wouldn't do it. I told them I need $67,000 and they said no. What else am I supposed to do besides take us to court and then complain in front of the judge saying it's all unfair and da-da-da-da?
Sometimes I'll start a sentence, and I don't even know where it's going.
I just could never imagine writing those letters and then having the audacity to say in open court, I've been cooperative and 100% transparent. You have been transparent in your demands. Transparency does not equal cooperation. And it's all to try to prove your side and the truth. It should never be this difficult to prove the truth. And so then she tries to dilute all of this into, because I'm trying to show and prove my adamant intentions of being in my son's life and all the things that I'm entitled to lawfully and the arrearages. You can't forget about the interest I'm also owed. It's not enough for me to try to take $67,000 from my son's household. I need the taxes on top of that. I need the interest on top of that because I'm entitled to that after killing someone.
The defiance is coming from the petitioner and his counsel by not abiding court-ordered payments and any other court orders in regards to the parenting plan and anything else that the court has proposed as of the official divorce. And that's including also attorney fees, which are self-inflicted when they have been truthful and ethical and providing the proper paperwork and a proper amount of time so I can actually review and correspond timely with the correct information.
Ms. Boone, you're way off base here. I need to know an opening statement is kind of a outline of what you intend to present at trial on the issues regarding the parenting plan proposed for the relocation and the modification of alimony and child support.
Thank you, Honorable Judge Jackson. Thank you,
Miss Jackson. Ooh, I am for real.
for putting an end to this never-ending rant, because she has no idea what an opening statement is. She thinks this was just her time to air every grievance imaginable, as if that's how the court system works. She's been going through the court system for over 5 years now, arrested George 5, 7, a million times beforehand. She is very familiar with how court systems work. She just refuses to abide by standards and just freestyles, says whatever she wants and says we need to be on my page whenever I say we are. Saying they're not following any of the court orders since the divorce. Yeah, and you didn't follow the orders of law in not killing someone, so things change. I never understand that, because how can you be the one to commit one of the gravest atrocities a human is capable of inflicting upon another human? Death, murder, killing them. Yet with your whole chest, you can point the finger at someone else and say, how unlawful, how unethical, how dare they not continue to pay me? I mean, we didn't put in my order of dissolution marriage agreement that I can't kill people and still get money. So if that's not written in there, then you're the one breaking the law. And this is completely unfair.
It was not fair. It's not fair. That she thinks she trying to say that that's what I did.
And all the attorney's fees are self-inflicted. So is your life sentence.
Ms. Boone, court sentences you to life in the Department of Corrections with credit time served.
Your life sentence is completely self-inflicted. Yet you want us to act like this is all happening to you. You had no control over this and thus are not bound by any of the losses and the consequences you have to face because of your intentional actions.
Well, if it isn't the consequences of my own...
Intentional, 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 intentional.
Actions. What's up? What's up? Trying to...
That's what you've shown. You want to show your adamant intentions to be a part of your life. You should have shown those adamant intentions to keep George alive, but you didn't. You showed your adamant intentions to keep him locked in there, laughing at him, having the best time of your life while his life is dwindling before your very eyes. Yet that means nothing compared to the injustice you are facing by not getting money you never earned.
Is my motion for contempt also included at some point?
No, ma'am, I've already dealt with the motion for contempt dealing with the application. Again, I told you what the issues were that we're here on today. You may continue, but let's talk about those issues. What do you intend to present as your evidence and your position regarding the relocation proposed parenting plan and the modification of child support, the modification of alimony, and the request for sole parental responsibility? Those are the issues that we're dealing with right now.
Yes, Your Honor. I was asking in regards to the motion for contempt in regards to alimony that does not have a judgment and has been continued up to this point. That was my question for the motion for contempt.
All right, ma'am, continue with your opening statement.
Oh, I love this judge so much. Just instantly put an end to the BS. Well, is my motion for contempt going to be decided? Since you won't let me air my grievances out, I need to make sure that my grievances will be aired out. And she said, if you don't move on, that is not why we are here right now. So please continue.
Has the court received my exhibits, please, Your Honor, that I sent?
We're not talking about exhibits right now. We're talking about your outline, your overview of what you intend to present to the court today.
What my case law and my exhibits that I'm hoping that you all receive.
You can continue with your opening statement.
Other than what I've actually already said, Your Honor, I'm not sure what I'm supposed to be doing, to be honest with you. So
Here, I'll stop for just a minute. Let me give you some guidance, okay?
Honorable Miss Jackson is nicer than me.
Sorry, Miss Jackson. Ooh, I am for real.
Because I would have been like, okay, bet. Brian's lawyer, call your first witness, because this is just going to go in circles anyway. But I don't know why she is so confused when she literally just went through an entire trial a year ago and had to go through all of these processes, like all of this before. You've seen opening statements by both the prosecution and defense, and now by Brian's attorney as well. You know what this section is for. You came in with an agenda and grievances you wanted to air out and accusations you wanted to make. And the fact that this is going out of order and you can't just wildly make them is throwing you. So the judge is going to try to offer you some guidance. I can guarantee you. I know that's right, Linda. I said, I know no matter what guidance your Honorable gives, it's still going to fall on deaf ears, and she's going to act like you didn't give her any guidance whatsoever, and everyone's just floundering and letting her fail at the
Sometimes I'll start a sentence.
They are requesting that you have one visitation per month with the child and one phone call per week. What do you intend to ask this court for as far as contact with the child?
Okay, yes, please, if you don't mind, I'm going to pull that from my pre-trial statement.
Oh Lord, not this pre-trial statement, this 33-page manifesto of a pre-trial statement. And I'm gonna go ahead and call it right now. She's going to use this for probably 90% of her answers because she didn't write it. She had her little flying monkeys, her friends outside of it, type it up, print it, fact check it, poorly apply case law, just putting the name at the bottom, because she definitely didn't do that herself. And it's just like in those prior hearings where she told Kranick, well, I have my 58-page letter because it's easier for me to write it out to you than to tell you.
Thank you. I actually have an envelope, please, that I would like to give to you regarding a letter. It's a lot easier for me to tell you in writing, and it's also put on the clerk of the court's website, so everyone is aware.
Where's the letter?
It's a packet,
Okay.
please. I believe it's 58 pages.
Meaning you don't actually know what you're talking about. You just know how to hide behind a pen, behind a keyboard, and behind words you don't think you have to back up. But now that we're in person and you have to back up these words, it's just going to be a mess. It's going to be like watching a student who plagiarized an essay try to give a book report on it.
Thank you, Your Honor. My request that I put in my pre-trial statement were to have daily telephone calls, if I would like to have them, with my son, which he would like to have as well.
Are we sure about that? With my son, which he would like to have as well. All the evidence points in the other direction, that he wants space from you and wants anything but daily phone calls with you.
I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night, every night. Tonight it rang and rang, then went to voicemail, then voicemail directly when I called back. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you, please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. Still trying to speak to my son. I am floored. You nor he answered the phone after calling 3 times on each. Let me guess, you're watching a movie. I've told you in the past what it is for me to get a phone call. Nonetheless, 3. Wow. Please tell him he is loved and missed. And tell son to plug in phone. Goes directly to voicemail, and I've been trying to call all weekend, day and night. Going to call tonight. Waiting still also for your response to any of my now 60 messages. Please respond.
That's insane. And yet again, I've mentioned this in the past, it's always centered around her, and then she attaches her son to it in order to legitimize it. I want you in a judge's order to make it legally binding that I am allowed to have daily phone calls. But she put the caveat, if I want to. Because what we find out when Brian testifies in a little bit is that she didn't call all last week, but she just so happened to call the night before the trial. So, all last week she was busy, she's doing this, she's doing that, but right before the trial, right now, she makes sure she calls him. So she wants you to write it down that she should be allowed to call him and get that daily phone call if she wants it. And then let me just tack on which my son would also want. I know it's a little nitpicky, but this is the director's cut, so I can do that.
Personal space and funds already added to the phone, so there's no interruption, please. Tablet credit for he and I to be able to correspond with one another and utilize the features of the tablet to stay in communication. Virtual visit on the kiosk. The in-person visit, I put 1 to 2 per month with the maximum allowable time afforded by the correctional facility, please.
You're saying 2 in-person, hold up, stop. I just want to make sure I understand. You're requesting 2 in-person visits for the maximum time allowed?
1 to 2.
Just pick one. Just pick a number. Just say 2. If they're already proposing 1 visit a month, then just say you agree to that aspect. Or say you want 2. Why say 1 to 2? That means they could do once a month forever and still be following your set parameters when in fact you know you want to. So just say 2.
Okay. Okay, you can continue. I just wanted to make sure I understand you. Go ahead.
Yes, Your Honor, thank you. I would like to be included in all holidays, including schooling holidays and any other time the minor child would like to include me.
Future me cut in. I'll do that from time to time whenever I want. Anyway, this one always annoys me more than anything. That's a lie. I'm going to say that exact quote so many times during this video. But being included in all holidays is absurd. She really said, watch out, Yom Kippur. I need to call you in advance of the Chinese New Year or else my whole year will be thrown off. How else am I going to prepare for our visit on Eid? I mean, I have to call you because you need to tell me what you ate on Juneteenth and if Cinco de Mayo is on a Tuesday. What? It's just absurd, right? Even when you had custody on the outside, not in prison for
life in the Department of Corrections.
You didn't have every holiday with him. Y'all alternated them. So why would you think, you know what, now that I'm locked up,
life in the Department of Corrections,
I'm really going to go for it and take all holidays. Also, just how selfish is that in general, that every single time you're allowed to have a break and celebrate, I need to be included. No matter what, you must include me. Even if I yell at you for days on end telling you you're a terrible former husband, you're a terrible son for not loving me enough, I still need to be included on St. Patrick's Day or there's going to be a problem.
I would like to compel the petitioner, please, to include me in any decision-making regarding the minor child. To enforce communication, regular correspondence of the petitioner with me in all available options, including phone calls, tablet messages, letters, third-party representatives, any manner necessary, please, that I request, so we can communicate between one another, which has been a huge problem in this entire process.
Third-party representatives is crazy. What? That is absurd. Like all the other things, I mean, it's still a crazy request, but whatever. Putting third-party representatives, strangers, in there is wild because you like to just throw around legal concepts and words. If they're your legal representative, they need proof of that. Are they your lawyer? Are they your family? Do they have power of attorney over you? How are they your legal representative to justify sending a serial stalker to this man's house because he won't answer a phone call? Nasty work.
And to please keep the respondent, myself, updated regarding the minor child's proposed vacations, appointments, meetings, any happenings in his life so I can be included. To please enforce perpetual cooperation of the petitioner with myself in order to simplify, relieve, prevent ongoing and future problems for myself and the son. And please to stop his intentional lack of, which he has been doing so throughout this entire case. To please cooperate and just try to simplify things. Include me.
It's always so funny to me that she gets to determine and to name everyone else's intentions. 100%, this is intentional. These are his intentions into not cooperating with me because he's not paying me exactly what I want and doing everything I want. This is intentional non-cooperation.
But not intentional. My intention was not to leave him in there. My intention was not to leave him in there. I didn't do it intentionally. That was not my intention. But my intention was not for this to happen. It was not intentional. It was not intentional. Not intentional. I didn't intentionally go to that because this was not in any way, shape, or form. Hand on the Bible, intentional. No, that's absolutely what happened. Intentionally. I didn't intentionally mean for this to happen. So you guys think that I intentionally didn't do it. That I intentionally did not do. Not intentionally. Not intentionally. Not intentionally kill him. I didn't do that intentionally. I did not intentionally do this. But my intent was not for that to happen. But you think that I did that intentionally. You think that I did that intentionally and not intentionally to leave him there. Or intentional. In no way, shape, or form was it intentional. Because now you all think that I had even more, in quotes, intent to do what I did then, which was not intentional. I'm being accused of something that was not intentional. I'm not admitting anything about being intentional and I killed George. Not my intent. It was not intentional. I promise you, it was not intentional. Which I swore my son's life was not intentional. That was not my intent. That's my intention. What, that it wasn't intentional? Yes, that it was not intentional. Not intentionally. We understand that.
You still did. I didn't do it.
Intentionally. Not intentional.
Okay.
This was not my intention.
You were trying to figure out what's going on. We're still trying to figure out what's going on.
Unintentionally.
However, you show her a video she took of herself saying, "This is for everything you've done to me." This, being me locking you in a suitcase and filming you, is for everything you've done to me. Yet she says that's not intentional, and how dare you accuse her of this.
So, what's next?
They're going to come and swab your fingers.
No, I'm talking about, like, in the long run. Like, what do I need to, like, do I need to be doing something, or, like...
I can't tell you, like, what to do.
I mean, like, so, like, for... Like, I don't understand. Like, I don't know if you guys are just gonna, like... Because it makes it sound like, to me, like, I'm being accused of something that was not intentional. I'm being accused of it.
Mm-hmm.
And a handful of other things that I'm being accused of.
Okay.
So I don't want to be at home with, and you guys show up.
Okay.
Meanwhile, she throws out every accusation imaginable over her personal feelings, not the actual facts of the situations, and not the actual facts of the reality in which she lives. But she's legit asking the court, I want you to compel perpetual cooperation with me in order to alleviate any stress or anything for myself. Oh, also, and the minor child and the son, but it's always centering around herself. And the judge knows this, and it's never going to work.
All right, I get the gist of that. They're also requesting that the alimony of $1,000 per month be terminated. What is your position on that?
Please, if you don't mind, I'm going to pull my paper.
All right, you're going to get a chance to present evidence. What I'm trying to find out now is just simply an overview, an opening statement, what the overview is of your position on everything, so that when I do hear the evidence, I know what I'm listening for.
Yes, Your
Okay,
Honor. Thank you for your paper.
I don't need specific language. Are you contesting? Do you believe that you should still be paid $1,000 in alimony per month?
I do, because the orders were active, including arrearage.
She's going to make sure that you know, including arrearage, because it's probably a word she just learned right before the pretrial statement. But this isn't an actual argument, and, you know, she'll have time to elaborate on this. But her only argument since the moment one for why she should keep getting alimony is, well, the order was active, including arrearages. That's it. You are here because you need to prove and argue why you deserve to get $1,000 a month despite being in prison for murdering someone.
We, the jury, find the defendant guilty of
life in the Department of Corrections.
Now that you are in prison, you are being taken care of. You have food, drink, water, shelter, and more friends than you ever had on the outside. Forced friends, people that you live with, your own community. You have more than you ever had on your own on the outside. Yet you still think you deserve just as much money as you were getting on the outside, with no explanation to back it up.
Right? Do you believe you should still be paid $100 per month in child support?
I do not. The petitioner and myself came to that conclusion when Judge Dean was on the bench, so that should be concluded.
Right. So you agree that Mr. Boone should not be paying you child support?
Correct. Yes, Your Honor.
Right. They made a statement that there is approximately $4,000 that is sitting in the clerk of courts with regard to child support. They're asking that that be returned to Mr. Boone so that he can use it to care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have in order to become more of an adult and his growth in his teenage years.
Then just ask for the money then. You're basically saying, yeah, I want you to give him the money back as long as I can control what happens with it. But no, as long as he includes me on some things, what does some things mean? Every single thing I request for him, put it on my tab.
To Walmart. He wants a bird feeder. He said there is a blank lands and tells me about the cardinals and other birds. He said blank. We're talking about springtime and Easter. Put it on my tab. Put it on my tab. Buy blank. Know what I owe you.
Well, I still have not recovered to this day from that concept of just, you need to buy anything I tell you to put it on my tab. And that's the stranglehold that she had on him, because she uses all of these orders and effects and things that are binding in order to control and make sure people can't leave her, which is why people leave her.
And his growth in his teenage years.
Like what? Like what? You need to detail what this means. This is the trial. This is not a we're going to check back. This is not the time for vague, undefined terms. If you want to be included with the money, which that's never been a stipulation, so of course that's not going to be actually up on the table. But if you're going to make that argument, at least get specific. I want to be included in being able to buy clothes for my son, Christmas gifts, or this or that. I mean, there's no way that's going to happen in terms of you don't get to have partial custody of the child support. Either it's going to you or it's going to him. Not, you're supposed to give it to me, but I don't want it for me, but I still want to have the control over how it's used as though it were mine. No. If you want to buy your son some things to help him grow as an adult, get a damn job.
With your broke ass.
Which you say you now work in the classifications department. Congratulations. Solicit the internet for money as you do anyway, but instead of putting it on your commissary for all your snacks and whatever you want, how about you actually use it to buy your son the things you want him to have? And I know she doesn't know, but she's saying, well, we already discussed this and that should be concluded, but it's not, because we have to make it official here. Why do we have to make it official here? Because you still asked for it to begin with.
All right, so Ms. Boone, what's going to happen now is because the petitioner is the one who's filed the petition to relocate and the petition for modification, he has the burden of proof, and so he goes first. So I'm going to allow him to present his evidence. He's going to be able to call witnesses and offer documents to the court. If he calls a witness to testify, you will have an opportunity to ask cross-examination questions, okay? Then once he is done with all of his witnesses and all of his evidence, then the court will turn to you, and I will hear any testimony, any witnesses you want to call, including yourself. And if you call a witness or if you testify, then his attorney will be able to ask you cross-examination questions, okay?
Yes, Your Honor.
And that was the end of the opening statements. Pretty clear cut and was indicative of how the rest of the trial went. Sarah was a hot-ass mess. Brian's side kept it short and sweet. Now going to transition into the closing argument, which is what I did not originally react to, and now I'm going to give some mild commentary on it. And to just appreciate the wonderful work that Brian's attorney did. He brings just the perfect amount of pettiness, and I would have been just very upset or dismayed if another attorney tried to take the high road and did not take the little jabs where you could have taken the little jabs. So let's go watch him take the little jabs.
Well, if it isn't the consequences of my own actions. What's up? What's up?
All right, petitioner's written closing argument. Petitioner Brian C. Boone, former husband, respectfully submits this closing argument in support of his petition to modify the parenting and support orders and in opposition to the respondent's requests, states as follows. 1. The evidence at trial and applicable law overwhelmingly support granting the relief Mr. Boone seeks for the benefit of the party's minor child. 2. Since the respondent's former wife incarceration in February 2020, Mr. Boone has single-handedly provided a loving, stable home for the child, covering all financial, emotional, and logistical needs without any contribution from the former wife. In contrast, the former wife, now a convicted murderer,
Will the jury find the defendant guilty of murder in the second degree as charged in the information? Jersey number 1, is this your jury verdict? Yes, it is. Jersey number 2, is this your jury verdict? Yes, it is. Jersey number 3, is this your jury verdict?
Serving life in prison without parole.
Court sentences you to life in the Department of Corrections.
Has been completely unable to care for or support the child, having had no overnight contact since her arrest in 2020. 3. At trial, the former wife stipulated that Mr. Boone could relocate the child to blank Florida. However, she did not agree to Mr. Boone's proposed parenting plan that provided for sole parental responsibility for Mr. Boone, 1 monthly visit with the child and the former wife, and 1 weekly phone call between the former wife and the minor child. 4. The former wife has shown no genuine accountability or remorse for the actions that led to her incarceration. The evidence demonstrated that she continues to deflect blame for her predicament rather than take responsibility. This lack of insight into her own wrongdoing heightens concerns about her judgment and fitness as a parent.
110%. And that is more than enough for Brian's side to win this, because it is absolutely absurd. In no real reality is someone allowed to react this way, or any normal person would react this kind of way to this situation. She has zero remorse. From moment one has felt nothing for him. She was too busy trying to figure out, why is he purple? Why is he purple?
I tried giving him CPR.
Yeah, okay,
but nothing happened. He's purple.
Okay.
Well, he's not necessarily cold, but he's stiff. And he's
Right,
purple.
okay. All right, listen to me. All right, okay.
He's stiff and purple.
Put your other hand on top of that hand.
Baby, I'm telling you. Just by looking at him, you can tell.
There's no way I could say how, why. So just by looking at him, like, why is he purple? Oh, that's normal. When someone passes away, lividity, you turn.
As soon as the heart stops beating, the blood starts to settle to the lowest points of the body. And then it just becomes very pronounced. So that's just called bleeding. It happens every night.
I'm like really scared. I want you guys to know that.
Which, looking back on that now, you can tell she did not care what the answer was. She wanted to plant in your mind, he's purple, so it must have been anything else than me just beating the F out of him and locking him in a suitcase until he dies. And then when they said, well, that's just what happens when people pass away, she's like, oh, well, I'm just really scared because that excuse is not going to work, so I'm terrified. Would you still have been scared if they said that this was some super rare thing that only a genetic disorder could have happened and no way spending the entire night in a suitcase would have actually killed a human being, so you're off the hook, go home now? Honestly, that's what she was expecting. She wanted a whole biology lesson before she actually gave a flying F about that man. And the next day in the interrogation, no emotions towards him. She tried to do the fake weepy cry.
I've really helped him. I've bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything that I did for him. Gone to see all his public defenders, go to the state. I've gone to the state. I did everything for him because I'm trying to help him, because I had hope in him. And he was trying. He was really trying.
I mean,
that was not my intention.
Well,
y'all don't have any idea what I've done for him.
But what was your intention?
Everyone knows. Everyone knows. Everything that I've done for George, and love him and continuously helped him throughout his life with me and made him a happier, better person.
And everybody has their limits.
Everyone knows that.
Everybody has their limits.
So it's like, okay, so while we're in a good place right now, I'm going to snap? Is that what it, while we're in a good place right now?
You did.
And the wildest thing about even looking back on this is that when she's talking about, I do all of these things, I'm amazing, I've helped him, she's literally like jabbing her hand like a spear at the laptop. She is angry that you showed her that video, and she wants you to know that everything you saw in that video of what I did last night, you have no idea what I've done for him. If you only knew all the amazing positive things I've done for him, you wouldn't even care for the fact that I killed him. You would say, oh my gosh, I can't believe how much you had to put up with. You are a saint. We're actually going to pay you alimony on your way out of here. And it's just crazy to say, while we're in a good place, you think I'm going to snap when they just showed you a video of you snapping. And if that is not a video of you snapping, then you are a terrifying individual. And then immediately the emotion melted away and she went back to normal, saying, oh, that didn't work. Okay. And not even on the stand. She's describing the most horrific things imaginable and saying it like it's absolutely nothing.
You said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then...
So the grip here.
Prodded at it, yes. I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
What was the first blunt impact injury that you identified?
So there were some blunt impact injuries to his head. I don't think it's on this one, but there were some blunt impact injuries to his head right up here around the eye and on the mouth area.
Did you notate any injuries to his hand?
Yes, so there were some ecchymoses, or you can think of that as like a large kind of bruise on both hands.
What other blunt impact injuries did you identify?
So there was a series of ecchymoses on the left side of the back, which right about here. There were some on the forearms as well.
For the split second reaction that I had, I happened to see that and I grabbed the baseball bat and was trying to poke his hand to go back in to please don't break through, please. So I hit his hand.
She's touching the murder weapon, the suitcase, zipping it, unzipping it, going here and there.
This was up here. This was not this hard either. So this was like here.
Okay. Just tell me what it's at.
I mean, it was the corner. I mean, the corner was kind of open. I mean, it's not. Yes, this one was pretty much, yes. From what I can remember. That's how he was coming with his hand out. It was like this from the corner part.
Okay.
Any regular person would be mortified to be in the same room as such a traumatic object if you actually cared about him. That was his coffin, you locked him in, and you get up on the stand and you touch it like it's nothing. And just so gross on so many levels, but shows absolutely no remorse. And even in this trial, she did nothing but deflect and say, my incarceration has nothing to do with any of this.
I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. It's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded.
Okay, well, it's not fair. It's not fair. It's not fair that you guys automatically blame it on me. It's not fair. See, that is just not fair.
I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release, and all other positive aspects that I have with my son on the horizon.
And it would actually be a stronger argument for her if she tried to take responsibility and said, yes, this horrible thing happened. It was a lack in judgment. It's not who I am. I can't believe I did that. That is not something that I normally do. And that is not the type of parent I am. And I still deserve to be in my child's life because I still have all of these good things to impart on him. And through my rehabilitation, through incarceration, I'm hoping to be able to impart good lessons upon him so he doesn't make similar bad choices and yada, yada, yada. I love him more than anything. Whatever. That would make you look at least more empathetic, and people might want you to have that relationship and to see, okay, there could be something positive here. But for you to say, I murdered someone, who cares about that? We shouldn't even be talking about any of this. It has nothing to do because I am still the mother of my son. Just because I killed a father of his own children.
He's always talking about his kids. Pardon me for saying, and a bitch, and not a mother.
Doesn't mean I don't get to make this about me. And it's because it's not even just you trying to dodge it, saying, well, we shouldn't even talk about the incarceration. Let's just say that's not even a factor. It's the fact that you're insulting it on top of telling us to ignore it. So not only are you saying this has nothing to do with it, and even if it does have something to do with it, it's just an obscure incident.
Explaining my dedication and my decisions and ideas and opinions, they matter. One obscure enforcement incident does not define me as a person or my entire existence.
One obscure, unfortunate incident does not define me as a person or my entire existence. And again, one incident does not define me or my entire existence.
One obscure enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself.
It's one dead Hispanic man.
Oh, like he does. Like, I get called everything but a white woman, so.
Why does anyone literally care? I am a white woman. He mistreated me, and now he's gone. Yay, everything should be happy now.
It's a Torres thing. Boo. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres. Getting rid of.
I truly do believe that she was using George as a phase, like a wild phase, and she always had the intention of trying to get back with Brian and going back to Playhouse, but wanted to have this wild fling, and now she murdered him, and it just shows that she never gave a damn about him.
5. A parent who cannot acknowledge such a grave error, a homicide that left her in prison for life.
To life in the Department of Corrections.
Is ill-suited to make decisions affecting a child's well-being. Florida's public policy strongly condemns violent criminal behavior. A parent incarcerated for a heinous, intentional act cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. 6. In fact, Florida law recognizes that a parent's lengthy incarceration for a serious felony is so contrary to a child's welfare that it can justify termination of parental rights. See MSB v. RB. While Mr. Boone is not presently seeking to terminate the former wife's parental rights, this principle underscores how profoundly the former wife's situation has undermined her role in the child's life.
Exactly, which is another blessing that she never appreciated. The fact is, 90% of the people in your situation would have had their parental rights terminated eons ago. because this is absolutely to that level. And if this were a TPR proceeding, you would probably lose that as well. So you are lucky that Brian wants you to be in your son's life in some capacity and does not want to take away all of your rights, just doesn't want to be bound to anything you have to say. You locked yourself away from society, so your opinion about what happens on the outside means very little. You are there to be informed and to maintain contact. Making major life decisions is something you cannot enforce nor have any genuine say. All you can do is bug the F out of them until they go to court to legally shove in your face an order, since you like to do that with everyone, the active parenting plan, stating, "Leave me alone."
7. Florida law presumes that shared parental responsibility is ideal, but that presumption yields when shared decision-making would be detrimental to the child. Here, sole parental responsibility in the father is not only warranted, it is essentially compelled by the circumstances. 8. The former wife has been entirely absent from the child's life for over 5 years and will remain so for the remainder of his
life in the Department of Corrections
minority, by virtue of her incarceration until life's end.
To life in the Department of Corrections.
She is unable to participate in day-to-day parenting or any meaningful decision-making. 9. Mr. Boone has already been exercising sole responsibility in practice since 2020 out of necessity. Formalizing sole parental responsibility in the father is necessary to avoid any confusion or conflict in decision-making going forward. 10. Awarding Mr. Boone sole parental responsibility will serve the child's best interest. The child is thriving under Mr. Boone's sole care, which provides stability, consistency, and safety, all of which would be jeopardized by giving the incarcerated former wife any decision-making authority.
That's exactly right. And she wants to talk about, can he accept the responsibility of these decisions if they go wrong?
How will this sole great responsibility, should it be awarded, affect the former husband's mental ability going forward, as all instances, scenarios, and situations are not the same?
I have all of this and all of that I can impart on him. He needs me. He needs his mom.
I love my son immeasurably and have a limitless abundance of positive, meaningful, solid, contributing life characteristics to share and have my son inherent from me, which is priceless. It makes no difference where I am. It's who I am. Mother, now and always. And again, one incident does not define me or my entire existence. I have so much to offer in so many ways, and it would be extremely detrimental, as well as a great loss, to not be able to continue in the shaping of our son and his very extraordinary life. Is former, quote, husband able to handle the consequences, burden, and heartache should his decisions jeopardize or harm the best possible outcomes and inhibit the absolute success our son could have been or had?
Meanwhile, he's over here in a biotech magnet school begging you to stop blowing up his phone. I think he's doing just fine. And if they were bound to her and her decisions and her quote-unquote rules because they quote-unquote matter, then what he's doing right now can be hindered. If she were granted that power and she says, well, I don't want him to go to this school, or I don't want him to go to this field trip or internship or this or that, everyone has to pause, and it's like going through speed bumps where at the end of the day, you're still going to get what you want, but now you have to include her, placate her, give her this, give her that. It's just a never-ending cycle, and no one's going to deal with it anymore. When you were on the outside and you were connected and you still had your freedom, everyone had to placate and put up with you. Now that time has passed.
11. It is simply not feasible for Mr. Boone to consult with a prisoner serving life without parole on major decisions about the child's education, medical care, or general welfare. especially when the imprisoned parent will have no financial stake or personal time investment in the decision itself. 12. More importantly, it is not in the child's best interest to do so. The former wife's inability to accept responsibility for her crime raises serious concern about her judgment. The trial evidence showed that rather than expressing remorse or cooperating in the child's welfare, she has made unfounded, inflammatory accusations against Mr. Boone. For example, accusing him of parental alienation simply because he has protected the child from exposure to trauma. Such behavior reflects a mindset that is not conducive to healthily co-parent or prioritizing the child's needs. 13. Consistent with the above, Mr. Boone's proposed parenting plan should be approved as it is tailored to the child's best interest under these unique circumstances. Mr. Boone's plan is generous yet prudent. It permits the former wife to maintain a relationship with the child through supervised monthly visitation at her correctional facility and weekly telephone calls. This plan ensures the child can have some contact with his mother, preserving their bond to the degree possible, without compromising the child's safety or welfare.
And she has no concept of that, or she hasn't acknowledged it, because the fact is, going to prison even once for any reason can be a traumatic experience, even if it's just going to go visit a parent, a child, a nephew, a friend, anyone. She thinks, because I know I'm not a danger to my child, I would never hurt my child, so there should be no reason why he shouldn't want to come see me. Meanwhile, every time he goes to see you, he's going to have to go through this processing. It's going to feel invasive. It's going to feel ultra standardized because it is, and the interactions will feel sterile because of it. It's not going to be a warm environment like she's imagining and like she's going to project onto him. Because if he shows any other emotion other than pure joy and happiness, she is going to just rip into him, trying to make him feel as guilty as possible. I can't believe it. Do you know how hard I fought to see you in person, and then for you to look at me wrong and to be spat on by you is unbelievable.
If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason.
And then as soon as he gets home, she'd be like, oh my gosh, I love you, I love you, I love you. I can't wait to see you again. That was amazing.
I love you, I love you, I love you, I love you, I love you. This is so overwhelming. If I were her son, I would probably panic seeing this. This is the definition of love bombing. Quite literally. Like, what is this supposed to do for him? Does you think he actually believes this because you say it a million times? It feels so fake, hollow, abusive, overwhelming, overstimulating, and self-serving. I love you, I love you, I love you forever.
It always centers around her emotion without any regard for the traumatic impact all of this communication and interaction with prison can have on a child. She doesn't care. She wants what she wants. And if you don't give it to her, you're the real villain.
14. The former wife's durational alimony award should be terminated retroactive to the date that Mr. Boone filed his petition to modify in April of 2022, due to the substantial change in circumstances and the elimination of her need for support. 15. Here, the former wife has no legitimate financial need for alimony at this time. Her incarceration means the state of Florida, at taxpayer expense, is providing all her essential needs, including housing, food, clothing, and medical care. She pays no rent, no utilities, no grocery bills, no insurance. The primary living expenses that alimony is designed to cover have been entirely assumed by the prison system. Any minimal personal expenses she might have, such as commissary items or phone minutes, are negligible and certainly not expenses the former husband should be ordered to finance. 16. In short, the entire premise underlying the original alimony award to assist the former wife's postmarital living expenses and transition to self-sufficiency has been upended. Given her life sentence,
Court sentences you to life in the Department of Corrections.
She will never re-enter society or incur the normal living costs that the alimony was intended to defray. 17. Put simply, the former wife's incarceration has extinguished any reasonable claim of need for alimony, and it would be inequitable in the extreme to force Mr. Boone to keep paying. 18. Moreover, the former wife's incarceration and conviction amount to a substantial change in circumstances that was not contemplated at the time of the divorce. 19. The former wife stipulated that Mr. Boone does not owe him child support since she was incarcerated in February 2020. 20. However, Florida law does not automatically extinguish a parent's duty to support a child due to incarceration. See Wilkerson v. Wilkerson. A parent's duty to support, quote, exists as a result of parenthood and is not erased by a criminal conviction. 21. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child's support. It merely rendered her unable to do so. The unfortunate result is that Mr. Boone and the child have borne the full financial burden with zero assistance from the former wife. For over 5 years, the former wife has paid nothing toward the child's needs. She also failed to exercise any visitation. 22. Mr. Boone testified that between February 2020 and April 2022, he provided the former wife with direct monetary support averaging $600 per month, in addition to paying $240 per month for a mini storage unit on her behalf. 23. During this same period, the former wife had a child support obligation of $367 per month to Mr. Boone, based on his exercise of 100% timeshare and imputed income of $60,000 annually to him, and minimum wage imputed to her. 24. Extrapolated from February 2020 through the child's age of majority in October 2028, a span of 104 months, that obligation totals $38,168 in child support owed by the former wife.
Yeah.
$38,168.
Homicide.
Bitch.
No, I'm sorry.
Child support she will never satisfy, given her life sentence in prison. 25. Even without giving Mr. Boone any credits and assuming that Mr. Boone owed the former wife the maximum amount of $26,000 in alimony arrears from February 2020 through the filing of the petition to modify in April of 2022. The former wife's child support obligation alone more than offsets any such claim. 26. This calculation does not even account for the substantial sums Mr. Boone actually paid her directly, the storage expenses he covered, or the more than $14,000 in attorney's fees he has incurred in protecting his child's best interest against the former wife's persistent obstruction. Accordingly, any claim by the former wife for arrearages must be denied, as the equities and evidence overwhelmingly establish that Mr. Boone owes her nothing.
Yeah. Double homicide.
Bitch.
Bon appetit.
27. For all the foregoing reason, petitioner Brian Boone respectfully requests that this court A. Grant his modification petition and deny the former wife's outstanding motions. B. Award him sole parental responsibility. C. Approve his amended parenting plan. D. Terminate his alimony obligation in order that neither party owes the other any arrearages for unpaid support. E. Order the immediate release of any clerk-held funds to Mr. Boone. F. Deny all relief sought by the former wife, including claims for alimony, sanctions, contempt, or attorney's fees. Certificate of service, I hereby certify that a copy of the foregoing has been applied to Mr. Joshua J. Martell. Great job. You ate with that one.
And that was Brian's closing argument. Really solid job. Love that he still used former wife in order just to throw that in her face, because she's been saying this for years as a sign of disrespect, and just to show you how foolish it sounds, he's going to actually use it in a legal document to reflect right back at you. Except his arguments are actually viable. And when you hear all that, you're like, he could have stopped after the first few sentences and that should have been enough to win it right then and there. But she does have a skill of making the most obvious conclusion seem like the most complex mystery imaginable. Not that she actually does a good job of convincing you that it is, but that she does a good job of making me believe that she believes it's this murder mystery type thing, and that the answers are all in the air and you have to talk and listen to her just to understand even a fraction of what's actually going on, when it really is as simple as you filmed yourself killing him.
Get the time frame out of your mind. This whole thing, it doesn't matter. It doesn't matter because there's this, so it doesn't matter anything what it is I say. So it makes no difference whatsoever.
It's just you're lying and like you're now changing your story.
Lying about what?
You're now you're drunk.
Oh, I never said that I was drunk.
You're in prison for life.
To life in the Department of Corrections.
You cannot raise your son. You are divorced. Leave this man alone. And hopefully, when we finally get this order from Judge Jackson,
Sorry, Miss Jackson.
we will all be able to collectively say with Brian, leave me alone. But for real, I'm hoping he gets his freedom soon. I'm hoping it becomes a huge sigh of relief for both him and his son, just realizing that they have more autonomy, that they do have the right to choose their level of interaction with her. They can still love her. I'm never going to say that her son should turn his back on her or shouldn't love her if he does love her. You know, his relationship can evolve into whatever it evolves into, and honestly, either direction is justified based off of how she treats him. He can either not let it affect him and love her regardless and still try to fight to make that relationship work on some level or capacity, or he can reject it and say, I choose my own inner peace, and once you learn how to act right, maybe we can revisit this. But until then, you need to sit in that cell alone for a little bit until you understand you are not entitled to people's resources, to have access to them, and to control their actions. She still has not learned that lesson, even after 5 years and losing a criminal trial, going through 9 lawyers. What is she in total? 9 lawyers plus Mr. Henderson and Mr. Beck, I think that's his name, plus these 4. So she's on 15 lawyers that she has gone through ever since she was incarcerated. Yet she will still say this whole process was so unfair. And she keeps saying that she was looking for representation, this and that. I almost forgot that Mr. Bankowitz was her family law lawyer. Her 6th attorney that she berated, that she called a dud, that she fired and pushed him away.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone.
Was her family law attorney as well.
1. Both parties appeared for the case management conference, which included a motion to withdraw by the respondent's counsel, Frank Bankowitz. 2. There were no objections to the withdrawal of respondent's counsel. 3. Frank Bankowitz is hereby removed as counsel for the respondent.
I don't know why he signed up for both of those, but he did. So she could have had help. She didn't have to go through what she went through, but because she acts the way she acts and she is who she is, she puts herself in these situations every time. But anyway, if you enjoyed this video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.